Welcome to another episode of our Fundamentals series. Today, we're going to be talking about the marketing rule. Before we get started, we always have to remind you that while we hope to have a lively discussion, none of this constitutes legal advice. So we ask you to review this disclaimer. If you need assistance, we're more than happy to help you, but that will have to be a separate engagement. Our next slide includes information regarding CLE credit, and we have information that we'll provide you at the end of this program as well. It's important to remember to answer each of the polling questions, which is a way of verifying the attendance. Today, I will be joined by my peers, Ryan Nichols and Chris Wilcoxon, and I'll let each of them introduce themselves as they join. My name is Amy Bowler, and I'm a partner with Holland & Hart, and I am currently the chair of our securities group.
Good morning, my name is Chris Wilcoxon. I'm an associate in our corporate practice here at Holland & Hart. To kick us off and make sure that everyone is awake, we're going to start with a polling question. Are you affiliated with, including as an employee, officer, owner, etc., an investment advisor registered or required to be registered with the SEC? Please take a moment to respond, and please be sure to click the submit button below after selecting your answer. So thanks for responding to the polling question. This morning, we're going to begin by discussing the background and purpose of the new marketing rule. Then, we're going to take a closer look at the definition of advertisement under the marketing rule. Next, we'll look at what you can and can't include in your advertisements. Then, we'll address changes to record keeping and reporting requirements for investment advisors and changes to Form ADV. Finally, we'll conclude with a few key takeaways to keep in mind when preparing for compliance with the new marketing rule. So first, back in December of 2020, the SEC announced that it had finalized reforms to modernize the rules governing investment advisor advertisements and compensation to solicitors under the Investment Advisors Act. These rules had not been significantly changed since their adoption over 40 years ago. So the new marketing rule went into effect in May of 2021. It is in effect today. We are currently in a transition period for these recently adopted changes. The 18-month transition period expires in November 4th, 2022, so it's coming up. Investment advisors impacted by the new rules should be taking steps to implement any necessary changes throughout their organizations now, if you've not done so already. Early compliance is permitted so long as advisors elect to comply with the new rules in their entirety, but partial compliance is not permitted. Which brings me to our next polling question. Have or will you elect to comply with the new marketing rule prior to the November 4th compliance date? Please take a moment to respond to this question, and please be sure to click submit after responding to the poll. And with that, I'm going to pass the baton to my colleague, Ryan Nichols.
Thanks a lot, Chris, and thank you, Amy. And thanks to everyone who joined us this morning. As you heard, I'm Ryan Nichols. I'm counsel in the Holland & Hart Investment Fund Group. This hour that we've set aside should be enough to whet your appetite and give you an overview of the new marketing rule, but we would need at least a day to actually satiate your hunger. So we're going to do our best to provide an overview of the rule and extra context where we can and where it's appropriate. So with that in mind, over the next 15 or 20 minutes, I'm going to chat a little bit about and dive into the definition of advertising in its component parts. And then I'm going to kick off a discussion of advertising content with an overview of the 7 prohibited advertising practices. After that, I'm going to turn the presentation back over to Amy, who's going to explore those advertising practices and content in greater detail. So first thing I want to chat about, who's covered. So the rule applies to any investment advisor that is or is required to be registered with the SEC and that directly or indirectly disseminates an advertisement. So to be clear, the rule does not apply to advisors that are not required to register with the SEC, including any exempt reporting advisors, even though they would be filing part of an ADV, or any small or mid-sized state registered advisors. So what is the reason behind the SEC's move to the new marketing rule? There's a few, and they speak to them in their 430-page release. But generally, the rule modernizes the advertising rules, and it reflects advancements of technology, changes in advertising methods and practices, the emergence and pervasiveness of social media in everyday life, whether for individuals, companies, funds, etc. It's also intended to be more of an evergreen structure by applying a principles-based approach as opposed to a rules-based approach, which will evolve as marketing and advertising evolves. The new rules represent a combination of the old advertising and the old cash solicitation rules under the Advisors Act. Respectively, these were adopted in 1961 and 79, so you can imagine the changes that there have been to advertising practices in those years. It also incorporates and supersedes a number of existing no action letters. And Chris is going to touch briefly on some of those prominent no action letters later on. So after reviewing the comments to the proposed rule, the SEC's position is that merging the two old rules into a single marketing rule and folding in the various types of communications under a single definition of advertising is appropriate to accommodate current market practices and their evolution, but will still achieve the SEC's longstanding goal of protecting investors from misleading advertisements and solicitations. And the SEC believes that it's going to be better positioned to comprehensively and efficiently regulate marketing communications as a result of these changes. So what you'll see, Chris, jump back one slide, would you please? Thank you. The definition of advertisement as a result of the merging of the advertising rules and the solicitation rules remains very broad. And it's divided into two distinct parts. The SEC refers to these as prongs, and we're going to in our presentation as well. Now, the first prong covers communications traditionally addressed by the advertising rule. And then the second prong covers communications that were traditionally covered by the cash solicitation rule. And I will in a moment address each of the prongs and their parts separately. Chris, you can advance, please. Before I do that, though, and as a preliminary issue, since the goal of our presentation series is to discuss issues relevant to funds and fund investors and their sponsors, is to make clear that the new marketing rule does apply to communications with both advisor clients as well as to private fund investors. So a private fund, consistent with everyone's expectation who's heard the term at all before, is a fund that would be an investment company, but for the exemptions available to it under sections 3C1 or 3C7 of the Investment Company Act. Now, as a reminder, private funds themselves are the clients of the advisors, and the investors in those private funds or other pooled vehicles are not the advisors' clients. So the specific requirements of the advertising rule didn't actually apply to communications made to private fund investors. Technically, that investment advisors are always subject to the overarching anti-fraud standards under 206 of the Act and other securities laws when communicating with private fund investors. And the SEC staff has even gone so far as to reference the old advertising rule when considering whether or not communications for private fund investors are in fact misleading. Some of the commentators proposed correctly that the Act already prohibits misstatements and material misleading statements to private fund investors, so why include them in the rule now? And the SEC agreed that they are covered by the anti-fraud rules, but it wasn't persuaded to exclude private fund clients from the new rule. And just as the new rule overlaps with the other anti-fraud provisions for direct clients of the advisor, it will now apply to private fund investors. I do want to point out, you can stay on the slide, Chris, you should realize that this is true only for investors in private funds. Other pooled investment vehicles, although the SEC kind of discussed it, their investors will remain outside of the scope of the new marketing rule. And that includes other funds that would be investment companies, but for Company Act exemptions other than C1 and C7. So now if I can jump into the first prong of the definition of advertisement, it covers communications other than compensated testimonials and endorsements. As I said, this is communications that were traditionally covered by the advertising rule. Advertisements under the first prong include any direct or indirect communication of an investment advisor that offers investment advisors advisory services with regard to securities to prospective clients or private fund investors, or such communication that offers new investment advisory services with regards to securities, again, to current clients or private fund investors. There's a lot to unpack here. So I'm going to just look at a couple of the key aspects of this definition. First, let's talk a little bit about direct versus indirect. In addition to direct communications with prospective investors, or investors as applicable, the definition is going to capture communications with, or that intermediaries are delivering on behalf of the advisor. And the simplest example is an agent that they have hired for this purpose. Indirect communications, however, can also be communications distributed by a third party, which are subsequently adopted. And we're gonna look at that right now, because the way this is framed, it really picks up a whole host of communications as advertisements. So, as I said, third-party communications, which are not intentionally commissioned by the advisor as advertisements, may in fact satisfy the definition of an advertisement if it's attributable to the advisor. And so you as an investment advisor, you need to be aware of how you're using, endorsing, editing, etc., any third-party communications. There are some long-standing concepts under the Advisors Act which are reflected in staff guidance called adoption and entanglement. And these capture circumstances where third-party information may be attributable to the advisor, and therefore that communication would have to be assessed under the advertising rules. The adoption will occur when the advisor explicitly or implicitly endorses or approves information after it has been published. And this could be, in the social media context, an endorsement through a retweet or a share or something along that lines. It's facts and circumstances based, but you get the idea. Entanglement would occur if the advisor is involved in the preparation of the information. And these are circumstances that are more nuanced than hiring an agent and delivering advertising materials to them. As I just alluded to, the concepts of adoption and entanglement are particularly relevant in the context of social media, where frequently, mindless posting and reposting, of which we're all aware, by advisors' representatives can really result in inadvertent advertising. And so having relevant policies to control and assess the use of social media are becoming as important than ever in the advisory context. I mentioned before how edits to or inclusion of third-party content can be an adoption or an entanglement. Edits really those come in the context of if you have a public forum available, online posting, comments on your website or on something which you've shared. And there's situations where perhaps you delete those. And those would otherwise be uncompensated reviews. But if you start to delete them or edit them, all of the sudden you're creating an entanglement where the language is an advertisement and it needs to be evaluated under the rule. You can avoid entanglement in these types of situations where the changes are based on pre-established objective criteria that doesn't either favor or disfavor the advisor. So if you're going to remove profanity or defamatory statements or threats, etc., those are reasons, as long as you have a long-standing policy, why you could edit third-party content without creating an entanglement. So as with most of what we're covering this morning, all of these concepts require a facts and circumstances analysis. But with regards to the nature of the communication, you really should ask yourself now, in the context of social media, is your communication an advertisement if you just repost or comment on an article link or other data? Do you have a pre-existing objective policy to edit or remove content or public postings? And again, in the context of social media, are you further exposing yourself to liability under the general anti-fraud rules by adopting posts on social media if they contain untrue statements of material fact? So just trying to emphasize here the importance of compliance as we move into this next phase of the rules. The second prong of the definition is for endorsements or testimonials, and this would include solicitations. As I said before, these were traditionally covered by the cash solicitation rule, which has been amended and merged into the advertising rule. This is going to include any endorsements or any testimonials for which an advertiser, either directly or indirectly, provides cash or non-cash compensation. I want to flesh out each of these kind of four elements right now. An endorsement is a statement by a person other than a current client or private fund investor that indicates approval, support, or any recommendation of the investment advisor, or otherwise describes that person's experience with the advisor. On the other hand, a testimonial is a statement by current clients or private fund investors about their experience. So again, endorsements, not current clients; testimonials, current clients. For both endorsements and testimonials, what we're looking at are statements regarding an advisor's investment advisory experience or their capabilities. However, the testimonial or endorsement could also be a statement as to qualities, expertise, or capabilities in other contexts, but to the extent that those contexts are relevant to assessing an advisor's investment advisory services. And those could be comments of character, etc. Let me talk a little bit about what is indirect compensation. The SEC hasn't given us a lot of discussion about this. For now, let's assume indirect compensation it's really overly broad, that they are not providing guidance on it. We'll wait and see kind of what becomes of that. But whether you're making a payment, whether somebody else is making a payment on your behalf, either as an intermediary or through some other arrangement, just be aware that compensation can be found in a broad array of circumstances. Now, cash versus non-cash, this represents a deviation from the cash solicitation rule that we were previously familiar with. There's a lot of examples that may qualify as non-cash compensation, but really you need to think, if anything is being given in exchange for an endorsement or testimonial, the baseline assumption should be that it is compensation. So in addition to cash, non-cash gifts, paying for trips, entertainment, meals, gift cards, fee rebates, etc., other indirect benefits. In each case, given to in exchange for an endorsement or a testimonial. Now, there are situations where an investment advisor may pay for a trip, a conference, a seminar, where the analysis might indicate that it is not compensation for the purpose of incentivizing a positive statement about the advisor. And that may be true. But at the time that person starts making those positive statements about the advisor, there's going to be a lot of scrutiny about, was the trip actually for that to induce them to make those positive statements? So again, facts and circumstances, like everything else we're talking about today. The SEC also did not want to, the SEC in the final release did not provide particulars about what compensation actually did or did not trigger this element of the definition. And they expressly said that they were not interested in providing a framework for advisors to avoid the application of the rule. And I think we should really just assume that the SEC is going to really, when they come around, they will really be looking at this based on the facts and circumstances, and you need to look at the relationship as a whole, the relationship with the person giving the testimonial as a whole. A couple of quick express exclusions from the definition of investment advisor. Communications regarding hypothetical performance. You may also hear these as one-on-one communications. So hypothetical performance is going to fall within the definition of an advertisement unless it's presented in one-on-one communications and is provided either in response to an unsolicited request or is delivered to a private fund investor. Another one is extemporaneous live oral communications. This is not an or proposition. This is each of these things. It must be extemporaneous, live, and an oral communication. These fall outside of the definition of advertisement, whether they're made in person or through a broadcast. But be aware that prepared speeches or other remarks, such as those that you would see delivered by script at an annual meeting, and any related written materials are not excluded under this extemporaneous live or oral communication exclusion. The SEC's goal, after it received input from commenters, was to avoid chilling communications to investors, and that may also affect the ability of the advisor to comply with its fiduciary duties. And that's really the reason for this carve out. If, however, speech or materials are prepared in advance, you should be aware that they are likely subject to the advertising rule and have to comply with all of the components of it that are the marketing rule, and will be subject to all the components that Amy's going to discuss. Also, those live communications, if you then record them or transcribe them and redistribute them, they no longer fall under the exemption. Statutory or regulatory notices, filings, other required communications, you want to be, the SEC wants you to comply with law. And you know, whether it's providing information in your Form ADV, if it's filing a Form CRS, any other obligations, the SEC wants you to be able to do this. And it's going to be an exemption or an exception from the definition, so long as the information delivered is reasonably designed to satisfy the requirements of the notice. And those all apply to the first prong, the definition, non-testimonials, non-endorsements. The regulatory notice applies to testimonials and endorsements as well. However, one-on-one communications and extemporaneous live and oral communications do not. Also, brand content and general education information and market commentary are not communications satisfying the definition of advertisement generally. I won't go into those because I'm a little tight on time. Yeah, okay. Let's go to the next slide, please. And we have our third polling question. So do anti-fraud provisions apply even if a communication is not an advertisement under the rule? And we have a number of options here. No, it does under 10b-5, it does under 17a, it does under 206 of the Advisors Act. B and C are true, B, C, and D are true. So just take a minute and or not a minute, a moment and respond, and we will kick off the actual marketing practices themselves. Chris, you can jump to the next slide, please. I'm going to talk about these prohibited advertising practices quickly as I can, and to give Amy an opportunity to talk about the rest of the content. But what we have here are 7 principle-based prohibitions on the content of your advertisements. The marketing rule use these 7 principle-based prohibitions to replace what were previously 4 prescriptive prohibitions. And as I mentioned before, the move to the principle-based prohibitions and the principle-based rules is really to make this an evergreen rule that adapts to changes in advertising, changes in marketing, and unforeseeable methods of advertising. So the first one is untrue statements or omissions. You may not include an untrue statement of material fact or omit to state a material fact necessary to make the statement not misleading. Now, again, fact-specific assessment. Some examples from the release are advertising high performance may be misleading if you actually were deficient in your performance compared to a similar index or benchmark that looked at the same group of assets. You can't say it's been a positive experience if you weren't actually a client of the investment advisor. It's misleading to use a testimonial or an endorsement if the advisor knows or should have known that it's fraudulent, misleading, or untrue. And you're going to see a theme here. These are all anti-fraud limitations. The next one is unsubstantiated material statements of fact, and an investment advisor may not include any material statement of fact that the advisor does not have a reasonable basis for believing it will be able to substantiate upon demand by the SEC. The practical point here is the advisors need to maintain evidence and backup for material facts in their advertising so they can substantiate it later. The SEC does not approve of advertisements in advance, and it may review them at any point for years to come when it conducts a review. And at that time, the advisor needs to be able to go back and find the backup that it used, that it relied on for making these statements. The SEC will make a presumption, it says in the adopting release, that if an advisor is not able to substantiate, or that if it is not able to produce the materials showing that it had a reasonable basis, then they will presume it did not have a reasonable basis. The third principle, is untrue or misleading implications or inferences. You cannot include information that is likely to cause an untrue or misleading implication or inference to be drawn about a material fact. A circumstance might be, we have 100 clients who have been with us for 10 years. Okay, well, maybe they used to have 1,000 and 900 of them left. The omission of that fact that could be used to infer something negative about the advisor could be a violation of this principle. This is kind of goes to the cherry picking idea that we'll talk about the 5th and 6th principles. The next one, the advisor may not discuss any potential benefits to clients or investors connected with or resulting from the advisor's services or operations without providing fair and balanced treatment of material risks or material limitations. So the advisor cannot come out and say, this is what we can offer you. This is why it's going to be great, period. You need to provide the risks. You need to provide the material limitations. Now, part of the fair and balanced treatment is assessing what risks should you disclose. Do not throw the kitchen sink at them. It's not going to be sufficient. Instead of a recitation of all the risks, note the material risks, the material limitations. We could jump down to 5 and 6. These are sort of anti-cherry picking provisions. Don't make reference to specific investment advice if it's not in a fair and balanced manner. Don't present performance results if it's not in a fair and balanced manner. Lastly, there's a catch-all. It may not be otherwise materially misleading. The advisor may not make an advertisement that is materially misleading. The SEC went so far as to say, we're trying to capture anything else. And the example that they gave was an advertisement which on its face includes all of the required information, but in really, really small or unreadable font. And that's the kind of thing that's supposed to be captured here. So the last point I'll make is negligence, simple ordinary negligence enough to fail in these principles. And you should consider your audience, because that'll change your appropriate response. For example, institutional versus retail investor. Thank you. I'm gonna pass it over to Amy, who is going to take over, starting with, I believe, testimonials and endorsements.
As Ryan already discussed, testimonials and endorsements are covered by the new rules. The prior regime prohibited these, but now you can use testimonials and endorsements provided that you follow the requirements. Whenever there is a testimonial or endorsement used, there must be prominent disclosure that you disclose both who the person is and what their relationship is. So whether they are a client or whether the endorsement is from a third party. You also need to disclose whether or not there's compensation, whether that's cash compensation or non-cash compensation, and a brief statement to the extent that there's any type of conflict of interest. Those all have to be disclosed prominently, according to the SEC, which usually means accompanying the actual testimonial. There also have to be other disclosures that do not have the equal prominence requirement, but nonetheless must be disclosed to any recipients of the testimonials or endorsements. And that additional disclosure includes discussing the terms of the compensation arrangement and also describing in greater detail any material conflicts so that the recipient understands the conflicts. In addition, there is a general oversight and compliance relating to testimonials, meaning effectively that if you're going to be using or adopting testimonials or endorsements, it's up to the advisor to be sure that the rule is being complied with. And that would be either directly being involved with adopting the testimonials and endorsements, or just making sure that if third parties are providing these testimonials or endorsements, that it's clear to you that you believe that that it complies with the rules in terms of the content and presentation. You are also required to have a written agreement with any person giving compensated testimonials. But that would exclude, agreement wouldn't be required if there was a de minimis compensation or compensation that's, less than $1,000 over a 12-month period. You wouldn't need a written agreement in that case. There are requirements with respect to using or compensating directly or indirectly for a testimonial if the advisor knows or should know that the person giving the testimonial or the endorsement is what they refer to as an ineligible person when the testimonial is disseminated. An ineligible person under the rules would be someone who is subject to an SEC opinion or order barring, suspending, or prohibiting the person from acting in any capacity under the federal securities laws. In addition, this would cover someone who would be ineligible under Reg D 506 rules that speak to disqualifying events and disqualifying persons. As we just discussed, there are a handful of exemptions to some of the rules that we just reviewed. One is that if an endorsement is disseminated for de minimis compensation, we just talked about that, 1,000 or less. It's not subject to the disqualification provision for ineligible persons or the requirement to have a written agreement. Those communications, however, are still subject to disclosure and the general oversight requirements that we discussed. There's an exception for testimonials by an employee or other affiliate, not subject to the disclosure requirements or written agreement requirement, but remains subject to the disqualification and general oversight requirements. It should be readily apparent, the affiliate status, or if it's not readily apparent, it should be disclosed. Registered broker-dealers really have their own compliance regime. And so to the extent that a broker-dealer is registered and subject to the broker-dealer regime and is complying with that, it doesn't have to also, in addition, comply with these rules. And I just mentioned that the covered persons under 506D would be applicable as well. And to the extent that you're complying with the 506D requirements, you wouldn't also have to comply with the ineligible rules here. You comply with one or the other, although they are very similar. We can go to the next slide. Third-party ratings. And so these are ratings that are truly third-party. These would be from unrelated third parties who are, who provide ratings and rankings in the ordinary course of business. And so to the extent that you are using a third-party rating or ranking, you have to conduct some level of due diligence to be sure that the process by which the rating agency gathers information is a process where anyone participating can provide favorable or unfavorable responses, and that the questionnaires are not designed to try and elicit a particular response. So you would either need to understand how the rating agency was obtaining information, or get reps and warranties from the rating agency about how they go about their ratings. And then you would have to clearly disclose the relationship to the ratings agency, and also whether you're compensating them for the use of those ratings. And we can go to the next slide. I always think that this is the heart of these rules. This is what everyone wants to talk about. So we've talked about what is advertising, who can do it, what are the rules for engaging folks, but now we get into the nitty-gritty of what is the information that you can and can't discuss, and what are the limitations on the information that you can include. Much of this will be familiar to folks who have worked in this space, because many of these concepts are already were covered in no action letters, and now they're being included, in the rule itself. And as Chris will discuss later, some of those no action letters will fall away. The rule sets specific conditions on how you can talk about performance, and effectively it reflects the SEC's belief that that the way you go about showing performance can be misleading. It's susceptible to being misleading. People have a natural inclination to try and talk about all the good things that they've done before, and explain away any blips or issues in the past that they think are not applicable, and try to present sort of a rosy picture. And so the SEC says, we got to be very careful how we go about presenting performance, so that people understand what you're telling them, and understand the parameters, and the assumptions and estimates that are included in what you're showing to them. So specifically, the marketing rule says you shouldn't be providing gross performance results unless you also present net performance results. And the net performance results need to be equally prominent, and someone should be able to compare the two, and understand how the differences are between the gross versus net. It should be very clear to them what is driving the differences between the two presentations. The performance results, the SEC has indicated that if you're going to show performance results, you need to show them for 1, 5, and 10-year periods, unless there are exceptions for private funds. You can show other periods as well if you wish. It's just that you need to include a minimum of the 1, 5, and 10-year periods. You, of course, as we all know, you can't state or suggest that the performance has been approved or reviewed by the SEC. We all know that. The presentation of related performance, which is performance of portfolios that are similar, a similar offered strategy. If you're going to do that, you need to include all portfolios with the similar policy objectives and strategies, so that you're, again, as Ryan just talked about, not cherry picking. So if you're going to go point to other portfolios, you're going to need to point to all of those that are similar. The performance results of investments that are extracted from a portfolio, so carve out types of performance results, can be used, but the advertisement needs to offer to show the full results, the full portfolio results, and you need to explain the parameters. What are you showing, so that people understand what is being showed, what is not being showed, what are the assumptions, estimates, limitations, what is in and what is out, in terms of what people are looking at, so that they can clearly understand what it is that they're looking at. Hypothetical performance can be used, provided that you have a policy and procedure designed to ensure that the performance is relevant to the likely financial situation and investment objectives of the intended audience. I think this is a tricky one. This is one that we will probably see, we'll need to get more guidance from the SEC on, but effectively the guidance is here, the rule says here, that it needs to be relevant to the financial situation and objectives of the intended audience when you are trying to put together the hypothetical performance. And you also need to provide sufficient information to enable the intended audience to understand the criteria used and the assumptions made. So again, helping the reader understand, what are they looking at, what has been assumed, what is being shown, what is not being shown, and what are the estimates that are included in how you are putting together this hypothetical performance. Further, you need to include sufficient information so that the intended audience understands the risks and limitations of using this hypothetical performance. What are the limitations in trying to present the information this way? In terms of, we can go to the next slide, which really talks about predecessor performance. Frequently, people want to discuss performance from other engagements, other funds, when they were working somewhere else. And so they want to be able to take that performance from their old firm and be able to talk about it in their new firm. And you are able to do that within certain parameters. And so if you want to talk about the performance achieved at a prior firm, one, we need to make sure that that what we're talking about, the people that we're talking about at the new firm are the same people who were primarily responsible for achieving the results at the prior firm. So you can't claim credit of other people. You can claim credit for what you were primarily responsible for. So if you or a team of people leave one firm and go to a new firm, to the extent that you were the primary folks who were responsible for achieving the performance, you can talk about the performance. The accounts need to be sufficiently similar. So you would need to be talking about performance of accounts or funds that are similar to what you're doing at the new firm. And they need to have been managed in a substantially similar manner, so that you were, it doesn't have to be exact, but it should be substantially similar so that it is an appropriate comparison between what you did previously and what you're doing at your new firm. And then you need to clearly and prominently disclose that what you're showing to investors relates to performance at a different entity under different circumstances. And of course, the general requirement that we've already been talking about is whenever you are showing any information, there's an overarching requirement that that the information be fair and balanced, that you tell the truth, the whole truth, nothing but the truth in your presentations. And as Ryan mentioned earlier, you also need to retain communications relating to performance. And you have to be able to substantiate your statements made. And it's important to emphasize that what the SEC is talking about when they're saying substantiate the claims that you're making, they want to point to information that you had at the time of making those statements. They're not saying that later on, after the fact, you can dig in and show why that claim was appropriate. They want you to be able to demonstrate that at the time you made the claim, you had appropriate substantiating materials for the claim. So one, you should be sure that whatever you put in here, you are able to substantiate, that you have materials and that you retain them in the files so that what you're producing to the SEC is your substantiation from the time of the claim, not later after the fact trying to justify and prove that it was accurate. And so with that, I will hand it over to Chris.
Thank you, Amy. So let's talk about substantiation. In addition to amending the cash solicitation and advertising rules, the updated marketing rule also amended the books and records rule. So the marketing rule now has updated record-keeping requirements for investment advisors. So advisors must now keep records of all advertisements that they distribute to more than one person, either directly or indirectly. Now, for oral advertisements, the advisor may instead retain a copy of any written or recorded materials used by the advisor in connection with an oral advertisement. And for compensated oral testimonials and endorsements, the advisor may instead make and keep a record of the disclosures provided to clients or investors pursuant to the marketing rule. The marketing rule requires advisors to retain the following key records: so written and recorded materials for oral advertisements, performance or rate of return written communications, accounts, books, internal working papers, other documents that demonstrate the calculation of the performance or rate of return of any portfolios. For supporting records that display hypothetical performance, copies of all information offered pursuant to the hypothetical performance provisions that we discussed, documentation of communications relating to predecessor performance, as we discussed, records of who the intended audience is, pursuant to the marketing rules, hypothetical performance and model fee provisions, Any communication or document related to an advisor's determination that it has a reasonable basis for believing that a testimonial or endorsement complies with the marketing rule. Similarly, any communication or document related to an advisor's determination that a third-party rating complies with the marketing rules due diligence requirements, and a copy of any questionnaire or survey used in the preparation of a third-party rating included in any advertisement. Now, we're also going to quickly cover the changes to Form ADV. So the SEC amended Form ADV to enhance the data available to support the SEC staff's enforcement and examination functions. The revised form requires advisors to disclose performance results, specific investment information, testimonials, endorsements, third-party ratings, and hypothetical performance and predecessor performance. The specific part that's been amended is item 5 of Part 1A. It now requires an advisor to answer yes, no questions regarding marketing activities in which they engage. Advisors must also disclose whether they have paid any cash or non-cash compensation for testimonials, endorsements, or third-party ratings in their advertisements. So we've discussed throughout that as of the compliance date, certain no action letters regarding advertising and payment of solicitors are being withdrawn or modified. And guidance addressing the prior rules is also going to be withdrawn. There are a couple prominent letters to be withdrawn. In the interest of time, I'll just highlight a few of these so that we can finish with a couple of our key takeaways for implementing compliance. One I do want to mention is Clover Capital Management. This letter previously outlined the items that in the SEC's view were prohibited in relation to performance advertising. It also clarified that advertising performance reflecting the deduction of advisory fees that a client would have paid or actually paid was the correct route to go. For Cambiar investors, this no action letter had previously clarified that the term testimonial included statements of a client's experience or endorsement rather than it only referring to statements of a client's experience or endorsement. So it broadened the definition there. Excuse me. Another one I wanted to highlight here was Franklin Management. The SEC had previously said that it would not recommend enforcement actions against investment advisors that showed only a partial list of recommendations if the recommendations were selected on the basis of objective, non-performance-based criteria consistently applied over time, and if the materials did not discuss directly or indirectly the amounts of the profits or losses of the specific recommendations. And with that, I am going to pass the baton back to Amy to finish us up with a few takeaways here.
Amy, you are on mute.
Sorry. Many folks have been working on this for some time, but if you haven't, now is a great time to get started because some of the changes that you'll need to make will likely take some time throughout your organization. First, which is self-evident, is that you would need to look at your existing marketing materials, and we've described how the nature and different types of materials that would be covered, and this can be extensive. And these materials can reside, depending on how you're organized. These materials can reside in different areas of your organization. So you need to first assess what do we say about ourselves, where do we say it, who else is talking about us, and get your arms around anything within your organization or even outside of your organization that might constitute marketing materials. So make sure you understand what that is, where is it coming from, and so that you know the universe that you need to be evaluating. Then, as we've talked about several times, we need to go through with a fine-tooth comb to make sure that whatever we're saying in all of these marketing materials can be substantiated and that we have a process. A lot of this that I'm going to talk about just relates to process. that you have a process for making sure that whenever claims or information is included in materials that might be considered marketing materials, that you are substantiating those claims and that you're maintaining files as backup so that if the SEC were ever to inquire, you could produce those records. So you need to have a process for reviewing the materials and making sure that you are documenting any claims in the materials. You also need to conduct internal training of all the folks who might touch these materials. And that, again, could be a lot of different folks. And so you want to make sure that in advance of these rules, people are aware of this. And it's not just the general counsel. Anyone who would be involved in preparation of these materials needs to understand at least some level what these rules are. We need to make sure that we don't have bad actors involved and that you have a process and procedure for evaluating those folks who might be engaged in the materials or who would trigger any of the bad actor requirements. So that requires some level of diligence on your part to make sure that you've examined that. We need to have internal processes and procedures to make sure that anything that would constitute marketing material is reviewed for compliance. So again, this is structure and process, and making sure you're implementing structure and process to make sure nothing leaves your organization without having a compliance review. Chris already talked about updating record keeping and controls. Again, this is just process and procedure to make sure you're complying. And we can flip to the next slide. I think we are out of time. These are critical in terms of time. We talked about how performance models have certain requirements. For instance, if you're going to show one related portfolio, you show all. You're going to show performance net of fees as opposed to gross. You're going to show performance at 1, 5, and 10 year. Some people are not, they historically haven't built those types of models into their system. And so to the extent you're going to be providing that information, you need to have data gathering processes in place and your model approach for how you're going to prepare all of that information. That is, for some people, those presentations are very different than what they've been doing, and it will take a lot to gather up the relevant information and create the models that will generate presentations of performance that reflect the new rules. And so you would want to be doing the legwork now so that you're able to provide that information. You would want to update all of your policies and procedures internally to make sure they capture the use of social media, online marketing, and being able to police testimonials and endorsements that can sometimes be out of your control. It's not always something that's emanated from your organization, and yet you have an obligation to make sure that it's complying. And then, of course, one final point is just to the extent that you need to enter into a written agreement under the new rules, you would want to make sure that you are policing that so that you do, in fact, put written agreements in place. So I think we are at the hour mark. We started a couple minutes late. We ended a couple minutes late, but we thank you for joining us. And Ryan, I don't know if you have any other wrap-up thoughts.
Yeah, thanks everyone for joining us this morning. We are going to continue our quarterly series in October, and we're going to be exploring a little bit about fund considerations as sponsors and as investors in connection with possible issues from a recession or downturn. That is hopefully not going to be applicable. However, we thought it was at least appropriate based on the current climate. So hope you can join us at the end of October for that. Thanks, everyone.